Good afternoon, everybody. Thanks for coming. Great to see such a good crowd. We have a treat today. We have Alon Harel, who is the Mitzvah professor in the Faculty of Law at Hebrew University. He is a prolific and engaging and thoughtful scholar that we're lucky to have, who's written so much about constitutionalism, legal theory. He's written in so many areas, I can't speak about them all. But books, constitutional theory, book Why Law Matters, Oxford University Press, Reclaiming the Public, Cambridge University Press. And we're delighted to have him. After he speaks, we will have Natalia Cerda and Oliver Gerstenberg will both give their comments, and then we'll have discussion. So,
Thank you very much for inviting me. It's a treat to be in Britain, because I told earlier that the intellectual life here is much more lively, much more to my liking than in New York. I've spent a year in New York. I quite a lot in New York because there was nothing going on. And I was quite right because there are so many events, and I can't. So I'm pursuing here what I started in my book Why Law Matters, which appeared in 2014. And the main claim of this book is that various legal and political institutions, procedures, they are not contingent, and their value does not hinge on the prospect that they will bring about the right decision. We usually think about them in instrumental terms. So we say we need courts to decide about things. Courts are good at deciding. We need a legislature. I'm thinking about many of these institutions from a non-instrumentalist, non-consequentialist view. And this book is intended to apply, or this manuscript hasn't been sent yet. This manuscript is not is applying this methodology or this approach to constitutional law. I'm going to speak about two chapters in this book. The second chapter of the book aims at understanding what constitutionalism is. Namely, is there a feature that is characteristic of constitutionalism? The fifth chapter argues that constitutions have distinct normativity, which differs from that of statutory law. Namely, there are some features that characterize the normativity of constitutions that differs fundamentally. More specifically, constitutional law is about duties or commitments we have, as opposed to norms that are based or hinge upon our preferences or choices. Okay, so let me start with chapter 2. What is constitutionalism? The problem in characterizing constitutionalism, and I've referred to it in an event that took place here a few weeks ago, is that constitutions deal with many, many issues, and many countries deal with very different issues. So the question of what it is about cannot be determined on the basis of, okay, it's about governing the society, it's about human rights, it's about this, because, you see that you have all of it. In order to solve this problem, or to address this problem, what I do is I want to look at two features of constitutions that I think everybody agrees are characteristic of constitutions. First of all, constitutions are highly important. And when we say this is a constitutional provision, we often mean this is very important, even if it's not in the Constitution, even if it's not formally there. The second element, or the second feature, is that constitutions are very salient in the public life. There are things that we think about, to debate about as citizens. It's not a technical area. I want to take these two features and try to see what can be derived from these two features. And here is a formalistic characterization of what I'm about to say or defend. There are norms and values that are particularly important. At times, they are not only important, but it's also particularly important to highlight their importance, to amplify their salience in the polity, to bring their prominence to the forefront of public life. Constitution contains those norms and values that need to be publicly recognized in order to be realized, in order that their goodness be realized. Hence, the subtitle of the chapter is on the importance of being recognized as important. So remember the two features that characterize constitutions that deal with important issues and they are very safe. Now, I don't say that each and every provision of every constitution satisfies this. I think it's a very characteristic thing. I think sometimes there are provisions that are not in the constitution and satisfy this condition. They're often called constitutional or super statutes or whatever. In the US, they have all sorts of names for them. In the UK, we speak about constitutional statutes. Under my account, constitutions are designed to signal that some values and norms are particularly important and that they need to be recognized as such in order for their value to be realized. And here you can ask a very basic question. Why should the importance of norms and values be stressed? Why do we care about that people will engage with it? Couldn't the polity simply regulate its affair in ways that are governed without requiring or inviting people to appreciate? Perhaps there are contingent reasons to highlight it. There are all sorts of things such that people could obey this or understand this and therefore be more obedient or more deferential or whatever. But why is it significant that people will recognize the importance of certain things? I'm going to start with a side from my supervisor, a person that I really admire greatly, but that's not the reason I provide the side. But the site actually captures the idea that there are certain values that need to be recognized in order for their goodness to be realized. Raz says the following: the value of object remains unfulfilled if not valued, is explained and further supported by a familiar fact that an object has value can have an impact on how things are in the world only through being recognized. The normal and appropriate way in which the value of things influence matters in the world is by being appreciated, that is, respected, engaged, because they are realized to be of value. The classical example of this is, of course, pictures. Yeah, many people. I don't want to get into aesthetics, and maybe there are some people who will disagree with what I'm saying, but it's a common view that beauty can be realized only when it's being recognized, or art, or whatever. I want to say that that's true about constitutional norms and how do I show this? I show this by looking at the three main functions or spheres that constitutions typically serve in liberal society, and not everyone in liberal society. And I want to show that in each and every case, recognition of the importance is crucial. It's a precondition for the value to be realized. So what do constitutions do? First, constitution establishes stable and effective institution of governance. Second, they protect human and civil rights. And third, some constitutions, maybe we don't like them, but maybe we do like them, but there are some constitutions that also establish language, religion, culture, history, connect the polity with this aspect. And I will argue that with respect to each one of those, it is ultimately the recognition and endorsement on the part of citizens that are necessary for these three areas to be, for the goodness of these three types of norms to be realized. So here are the three aspects. By stressing the prominence of public institution of governance, the Constitution transforms people into engaged citizens who participate in governing their society. By stressing the prominence of rights, The public constitution transforms people into appropriate right holders, namely right holders who do not only have rights, but also exercise these rights. In order for the value of freedom of speech to be realized, we need to exercise it. If it exists there, we have, nobody bothers us, but we don't use it, it's not valuable. By recounting a national cultural narrative, the public constitution transforms people into members of a national and cultural community. This account, stressing the public endorsement of constitutional norms on the part of the polity, on the part of citizens, explains why constitutional law is perhaps the least technical field in other words, everybody can debate about constitution. Every citizen, even idiots. Especially. These are concepts that citizens can engage with without being legal experts. Note that this is not a stipulative definition. It is instead aimed at focusing attention on important feature of existing constitution. I don't say that every norm and every value that in the constitution satisfy this, and I don't say that every norm, every value that exists outside of the constitution doesn't satisfy. To sum up, the public constitution is that constitution that invites citizens to participate in the public life of the polity and transform them into citizens who participate in the public life of the polity, into appropriate right holders who exercise their legally protected rights, and also in the relevant jurisdiction, transform them into members of culturally and historically rooted community. To successfully do this, the Constitution must stress the prominence of the norms and values it contains. The most fundamental concern of the public constitution is to mark certain norms and values as important, to make them salient, to amplify their presence in the public sphere and enhance their visibility. The importance of being publicly recognized as important. Okay, that's chapter 2. Thought it's chapter 5, but I wrote here chapter 4. Anyway, one of the chapters. In the Jewish Haggadah, which is written, which is read on Passover, God, there is a statement attributed to God that says, God killed all the elder sons. I think it was only sons, no daughter, I'm not 100% sure, no. Elder sons, all the sons in the family of the Egyptian or something. And in this text, it's not very nice to do, but he did. And in this text it says, I am not an angel. I am not a seraph. I am not a messenger, and not a messenger. It is I who did it, none others. It's very interesting because what is important here is that God says that it's particularly important that he or she did it, not what they did, but the agent who did. That's something that I stress in the book Why Law Matters very much, that who the agent is very important. And the question I ask is why, basically, why should we care whether it is God or a messenger that it is, as long as he killed all the people that ought to be killed there? And similarly, why should we care whether a constitutional norm or a statutory norm is the one that protects us? Why? I mean, of course, there are pragmatic reasons, because it's very difficult to, it's sometimes important to entrench it in a way that would be difficult to change, but these things are empirical and instrumental, therefore they don't interest me as a philosopher. Yeah, when I do philosophy. Okay. And what I'm trying to say is that the value of norms does not depend only on their content. They can be good, but it's important whether they're constitutional or statutory in ways that mean that basically norms provide what I call institution-dependent goods. The value depends on the institution that makes them. More specifically, constitutional norms serve to publicly affirm obligations and commitments that bind us independently of our political will. It's important that they bind us independently of our political will. It says something about them, and that's their role. On the proposed account, constitutional and statutory norms are not mere means to create good or just norms. Instead, the value of these norms hinges on who made them, who created them. At the most fundamental level of this analysis lies a distinction between three types of demands. There are universal obligations, right to life, dignity, for protection, I don't know, whatever, autonomy, all sorts of nice things. And those are independent of our will. They are binding because they protect what every state protects. Some demands are what I label commitments. In other words, those are things that we commit ourselves, and the value it comes from the fact that we oblige, we vow to do them. So a federal state, a Jewish state, republic, yeah, there are all sorts of constitutions that include these features. Not every state ought to be federal, yeah, not every state ought to be federal naturally, but we commit ourselves to this. In the case of individuals, I can commit myself to say I'm a loyal partner, I'm committed to help the poor, and so on and so on. But commitments are a subset of choice, but they are distinctive choices. They are ones that have strengths. What I'm arguing in constitutional lawmaking is necessary to convey our publicly shared recognition that certain norms, such as fundamental rights and core commitments, are binding independently of our will. It is only by being immune to public opinion or the general will that such norms gain their value. Hence, contrary to the prevalent view of political and legal theories, processes of majoritarian decision-making undermine rather than reinforce their value. One way of articulating this argument is to maintain that constitutions have a distinct normativity, which is different from the normativity that characteristic of statutory law. This may sound very abstract, but think about the 13th Amendment of the US Constitution, which prohibits slavery. Why do we have it in the Constitution? We have it in the Constitution in order to indicate that binds us independently of our will. The institution creating the norm, in particular the type of deliberation, is a form by which the polity indicates, acknowledges, recognizes that this is a duty it has, independently of what it contingently wants. Hence, constitutionalism is not designed merely to protect particular norms from being eroded. It is important to recognize their distinct value. The goods provided by the Constitution sometimes hinge precisely on the fact that they are incorporated and that it's difficult to change them. Receiving such broad affirmation implies that the goods conferred by the right, the goods of slavery-free society, does not reflect what people want or prefer. The right reflect, and if it was in statutory law, it would mean that we can change it. It's up to us. But no, I want to stress, constitutional demands are not up to us. They are either, it's indicated there are either universal obligation or, so if we had the 13th Amendment in statutory law, the society that has it in statutory rather than in constitutional law, it means it actually implies that it is up to us. Democracy becomes particularly appealing if the right not to be enslaved does not depend on what we wish. Further, I would say that ironically, this observation make it more rather than less democratic. And the reason is that we can convey what we believe to be binding independently of our will and put in the Constitution, and what we believe is up to us. So it enriches the public discourse in ways in which, if everything just depended upon what we prefer, we couldn't distinguish these two. I can believe that the prohibition on slavery is a universal obligation, and Jeff can believe that it's up to us on the basis of our preferences, and we can legislate it. But the fact that it's in the Constitution forces us to signal what the underlying grounds are. Now, this account has both theoretical and doctrinal implications. And when I say doctrinal, I'm a little bit intimidated when I meet constitutional lawyers because I know very little about this doctrine. I try to study, but it's very difficult, and more difficult than people think. But I would want to say that there is that it has implication. I'll show it by looking at the American jurisdictions. Some of the goods that legal, so theoretically, some of the goods that legal norms provide are institution-dependent goods, namely goods whose effective provision depends on institutional time procedural processes that bring these norms into being. Constitutional law, statutory. Doctrinally, I want to argue that choosing one or another institution to entrench a norm should not be governed exclusively by pragmatic consideration. And here I want to bring an example from the US Constitution. A constitutional right, what you find very often in the US context is that you have constitutional provision and, of course, often determined by the court, and statutory, separately. Now, this could look ridiculous. Why should we have same-sex marriage, for instance? It was first established. It's still in the statutes of many states, yeah? Constitutional right to same-sex marriage can also receive popular recognition by enacting a statutory norm. Supplementation can also occur in the opposite direction. A statutory right, insofar it signifies that people choose or judge to be just, can further receive the shared public recognition that this right is also obligatory. It's a duty, it's a universal duty, or it's a commitment in instance. This is not an exercise in duplication. This actually conveys that we both want it, and we also think or believe, or it binds us independently. But there can be even more interesting, I think more interesting cases. And these are the cases where you have statutes that conflict. I see that you already sealed them. You can see it in the statutes concerning abortion. Of course, now abortion is constitutional, it's been reinterpreted. But take after Roe versus Wade, there were many abortion laws that remains on the book. My analysis implies that there is a value in the coexistence of constitutional norm that dictates that you cannot limit abortion, you can regulate it, and having the particular laws. Leaving the unconstitutional norms against the Constitution in the statute book indicate what the majority of the people have chosen, and further that each choice might give way to universal obligation or to fundamental commitments of the polity. I'm doing a short summary, so coming to that. The book argues that the manuscript argues that constitutionalism is not merely a legal device to entrench rights, structure governance, constrain majorities, or realizing other moral ends. Cerda argued that constitutionalism is a distinctive normativity of its own, one which is not derivative of morality. At its core, constitutionalism is a political moral practice rooted in public recognition, in the collective affirmation that certain norms and institutions matter and matter publicly. Further, the fact that they matter publicly is necessary for their value to be realized. The public constitution is not defined by formal entrenchment, canonical text, institutional design alone. These may be means, but the end is recognition, participation, and transformation. In this sense, the contemporary crisis of constitutionalism may stem less from constitutional overreach than from constitutional misunderstanding. Failure to appreciate the role of constitutions. And therefore, I want to say that this paper will change the world and will impact ours. Thank you very much.
Thank you very much. That was great. So we've got two ECL colleagues to comment. We'll start with Natalia Morales.
Thank you very much. And thank you for carrying the manuscript. I really enjoyed. And obviously the book addresses like different topics. So I'm gonna focus mainly on chapter 2, I think it's 2, and then chapter 3. So my first comment, after reading your book, especially those 2 chapters, my immediate question when reading it was, who? Because I was wondering then, my first concern was, if we say that the public constitution is the importance of being recognized as important, then my first question was, okay, who decides what is important? I think that you give some ideas about that through those chapters, and then after the 4th, 5th chapter, I think you give some ideas about that. And you talk about participation or public engagement. And also when you discuss the constitutional importance of the Bill of Rights, especially when you say at the end of chapter 2, the public constitution is that constitution that it binds citizens to participate in public life. But you also say that in the same chapter that the public constitution is a means of communicating to citizens what they should regard as important and what deserves to be the focus of their attention and active engagement. So that gives me the impression that it is a one-directional exercise, whether from the top or from other place, maybe, to where citizens are told what should matter to them. I'm going to return to this idea when discussing about the idea of the people, but I think that that's the first question, right? Who? And then you talk about constitution making in the second chapter as well, and you say, in drafting a constitution, the constitution maker should constitutionalize norms and values which are both important and whose importance needs to be acknowledged and affirmed. And this really made me think about the Chilean constitution making processes. Because I think it challenges this idea, these 3 processes. In the last 9 years, we had 3 constitution making processes. And in the second one, actually, this is interesting, the economists call the process the wish list of left-wing political parties. The third constitutional process, the New York Times described it as a conservative manifesto. In both cases, the Constitution was treated as the political manifesto of one side of the political spectrum, 2 different sides of the political spectrum. And assuming that in both cases, the constitution makers were acting based on the deep conviction that what was included in the Constitution was the important matter, the important things. Well, the thing is that the outcome of that was 2 completely different constitutions. And I think then this is based on your idea of the public constitution, it means that in a period of 2-3 years, we got 2 completely different ideas of constitutionalism in Chile. That could happen in a 50 years period, but in 2-3 years, seems like a difficult case. And I think that you in this chapter, you made the example of the Constitution of California, the provision that golf. Yes, yeah. I think that's an interesting example, but I think that the Chilean case is a little bit more complicated because we're not talking about 1 or 2 provisions. We are talking about the whole constitution, 2 completely different projects, 2 completely different ideas of constitutionalism based on the idea of the public constitution. And with this, I think I can connect my next comment, which is connected to chapter 3. You provide 2 ideas of political representation, and then the representational constitutionalism has 2 different concepts of political representation as well in that chapter. But I think that none of those approaches fully captures the idea of mutual formation of agreements. The idea that legitimacy emerged through an ongoing dialogic process or practice between representative and the represented. So I was thinking that maybe those two ideas are too narrow in a way. And even when reading your chapter, I thought, well, maybe there is a third dimension somehow present in the work that you explore a little bit, but you don't mention it explicitly, as a legitimacy as a performative recognition in a way. And I think that this will reconceptualize the Constitution not as an already legitimate voice of the people, but
No,
not
as a performative what, sorry?
like a performative recognition. So if you do this, if you try to explore the third dimension, and I think you have some ideas about that in the chapter already, the legitimacy, the idea of the voting constitution is not, it wouldn't be like an already legitimate voice of the people, but it wouldn't be either like a container for reasons, the reason-based approach. But it will be a space where legitimacy is continuously enacted through interpretative, participatory, or even through process of education. And I think that you mentioned some of those ideas. You talk about the educative component as well. So I think that if you do this third approach, I would reframe the question from why are constitutions legitimate into a different question. How is legitimacy enacted, contested, or how is an ongoing process in the relationship between citizens and constitutional norms? I think that even in your approach, legitimacy cannot rest only on being recognized as important, but it emerged from recognizing others as a co-participants in defining importance. So I think that's slightly different than you do in your chapter, and I think it could bring like some other aspects. I think that goes into, I don't know how many minutes I have, so I want to maybe, that goes on to.
Yep, 3 more.
Okay. So maybe I'm gonna keep some of my comments. Well, yeah, there's another comment on the idea that the distinction that you draw between agency-based representation and essentialist representation. I think that you described the first model basically as a procedural matter. So basically, what matters or what is essential here is a ceremonial procedure. You use that phrase. That's ceremony. It's just a procedural aspect.
Agency based on the preferences of people, essential means that you capture their real essence independently of their preferences. So you're Hungarian, therefore. That's the
Essentialist.
Yeah, essentialist.
Yeah. But I'm not completely sure about the distinction, because I think that even in the more conventional or agency-based idea of representation, there is even in that conception, there is also an essential element of trust in the relationship, something that cannot be reduced, I think, to a purely procedural component. So I'm not sure about the distinction, because even in the agency-based conception, there's still an element of trust that cannot be reduced to a procedural aspect. And I think that this could be connected to where you speak on representational constitutionalism, and you talk about the people as embodiment of our values or collective will, and a reflection of who we are. And I think that was interesting that in the footnote, you include references to Loughlin, Rubinelli, Colin Rios, on constituent power, and probably on the idea of the subject of constituent power, and perhaps also how this relates, how this connected to the distinction between the people of the holder of constituent power and the conditions of how to exercise the constituent power. And I think that you leave that in a footnote, but I think it is important that if you have that distinction, it could be helpful to clarify some aspect of the legitimacy of the representative relationship, and I think it would be important to make it more explicit.
Right.
And my last comment.
No, you
my last comment, I think it goes on the idea of legitimacy as social acceptance or legitimacy referring to the moral ground of the Constitution. One could say that in the Chilean context, the discussion about the 1980 Constitution has been framed mainly in terms of its normativities. It's basically normative. And from this perspective, some people argue that the Constitution has been successfully used by democratic governments in 35 years more, and has been useful to recognize and protect rights. And also because of several amendments to the Constitution, the legitimity concern is not that strong anymore, even though it was enacted under a dictatorship and in a not participatory process. However, the concern about the Constitution today seems to lie in the acceptance and recognition of the constitutional text as our Constitution. The idea that connects with your approach of descriptive legitimacy, referring to this sense of national ownership or collective identification with the constitutional order. But the thing is that even without descriptive legitimacy and the lack of representative legitimacy, because it was adopted with the dictatorship, the normative form of the 1980 Constitution is generally accepted. In other words, Chilean people seem to be willing to acknowledge its binding authority and consider themselves that they are bound by the Constitution. And actually, but again, the symbolic problem, the symbolic stigma of the Constitution is still there. So people still talk about the 1980 Constitution as the Constitution of the dictatorship, of the Constitution of Pinochet. And to complicate even more this distinction, there are voices now in Chile saying that after the three processes, Chile does not really have a constitution. We just have a set of norms that are useful to exercise the power, to have elections. Actually, we are having an election this Sunday, so it's working. Thank you, we need it. But it's just a set of norms. There is no actual constitution. And I think that also complicates your distinction. And so how those cases could fit in your model of legitimacy. Maybe you need a more. I thought about Vicky Jackson's idea of the conception of legitimacy as a normative yet evolving process. So I think that could be useful. But yeah, I think running out of time. So
Thank you very much.
Thanks.
Now, other necessary.
Thank you, Ronan. So I approach my task with a sense of trepidation because this is incredibly insightful piece of work which you have, and there is much to learn from it, and I myself learned a lot from it. And we have also already discussed a little bit in person over lunch several times in German in part. So because Alon speaks German fluently.
Tries to speak.
No, don't be too modest. And so it's all very impressive. One important idea in Alon's work of many is what he calls the key takeaway of his investigation, that constitutionalism is a necessary feature of a liberal society. And related to that is the question, what accounts for the publicness of a constitution, because he calls his book the public constitution. And that, I think, is a question of great urgency, because it suggests that the constitution is not just a transactional matter. It's not just we might need a response to those who currently are democracy has not worked for us. So the question is, how do we account of the publicness of the Constitution? And there is an idea, we don't call it that way, but I think it is very present, of constitutional dualism, namely the distinction between constitutional law and ordinary law. So why do we, and this is what you referred just to in your talk to, why do we need constitutional law at all? Why not just live with ordinary law? Why the hassle? And so what accounts for the publicness of a constitution? And to illustrate, assume as we are sitting here, were to found a republic or a state. And then the question is, what would be the common point of view, the publicness, which allows us to speak together and to proceed with this founding act? Now, the main question now is how to achieve this publicness. And here there is possibly a difference between us, though it is more of a family quarrel, and because it is within a large set of shared assumptions. And there is, at least on my side, a lot of learning from your work. Alon's idea is a content-independent conception of a constitution. Mine is a content-dependent and interpretivist conception of the constitution. And what do these terms mean? Well, content-independent usually is used in the debates as without recourse to moral judgment, authority without recourse to that, whereas content-dependent is the idea we cannot possibly make sense of a constitution without recourse to moral judgment. We need moral judgment all the way up, all the way down. So that is the main a difference which I would like to press, and with a sense of trepidation and uncertainty about my own views. Yours are influenced by Joe Raz's work, mine are by Frank Michael and Ron Rolder's work. So, but it is, the question is, how does it really amount to very much? Now, and this issue could be broken down to three questions first about the legitimation worthiness of a constitution, and secondly, the role of judicial review, and thirdly, the nature of constitutional theory. So I think I will mostly speak about the first one, perhaps time permitting something about the second one, and be just silent about the third one, probably. Let us see. So central to Alon's work about the question of authority, of the legitimation worthiness of a legitimacy conferring and binding constitution. So here Alon speaks, of course, of moral legitimacy as opposed to sociological or descriptive. And often Max Weber is used in this connection, but interestingly, Weber was on both sides. He was not only a sociological legitimacy, but also moral legitimacy. And Alon's core term here is, or core idea is, a distinct normativity of constitutionalism. And now here is a set of ideas which I will take as my target, if you will. So Alon rejects a means to an ends view, the view that to justify constitutionalism, one needs to identify, and I quote him here, an end that is the protection of rights, the rule of law, stability, coherence, assurance, or liberty, and then establish that the constitution are contingently conducive to this end. So note here the idea of a constitution as something that hovers above these ends and is not reduced, Alon says, to something that is being merely instrumental to that. Yet Alon still insists that constitutional law, and observes or acknowledges that constitutional law is suffused with moral concepts such as equality, freedom, and dignity. And interestingly, he gives this a civic Republican slant by saying that these concepts are an open invitation for you and me, for citizens, to actively engage and participate in the public life of the polity. So we discuss them, we participate and discuss them. Yet, Alon also insists that his account of the public constitution, quote unquote, does not rest on the content of the constitution, but is, and I added, and this is what I took from your presentation today, a source-based view, the question who made it. So it is not derivative of morality, as you say, but based on an idea of recognition. Now, the core claim to bring all that together is, of course, Alon's view and this will be one of my targets today, is that the fundamental concern of a public constitution is to mark certain norms and values as important, to make them salient, to amplify their presence in the public sphere, to enhance their visibility. So my first sense here was that there is a tension in your account between both these ideas, namely, on the one hand, the Constitution as a convention, as a content-independent rule of recognition between and among the citizens, so not merely officials, but the citizens. But on the other, the acknowledgement that constitutions are suffused with morality, with moral concepts. And I think these concepts of the recognition that moral concepts of equality, freedom, dignity presents a difficulty for your account. So here is my critique, here is my contrasted account. So I would argue that we cannot understand and make sense of the authority, legitimation, worthiness, and everyday operation of constitutions without recourse to moral judgment and without recourse to the content of a rights-bearing constitution. Of course, an echo here in your work is Hart's remark about our H.L.R. Hart's idea to preserve the core principle of legal positivism, that the law of a community actually depends on nothing more than the contingent aspect of its social and political history. Political and morality has nothing to do with that. Against this, my point is the highly abstract, so the question here is, or the point here is that the highly abstract constitutional provisions of a rights-bearing constitution are not merely social facts known in advance. So when Alon says to mark certain norms and values as important, to make them salient, to amplify their presence. So my response to that, constitutional provisions are not just social facts known in advance that only need to be amplified, exposed, and made visible in the public sphere. But in any given situation of constitutional application, we need to know why these constitutional provisions are salient in order to progressively clarify their meaning and to concretize them. So take any constitutional provision, take any practical constitutional debate. Should freedom of speech prevail over your right to privacy? We must interpret these concepts. This is not merely an effort of making them visible, of amplifying their presence, but of engaging with them, of asking what are the reasons for the salience of these concepts, and only then can we proceed in creating an order between these contexts in a specific situation. So why then, and this is the first point here. The related point is, why then do we need constitutional law at all? Why not just stick with ordinary law? And here the idea is that the meaning of evaluative concepts such as equality, freedom cannot be simply read off from our evaluative moral, cannot be simply read off from our moral concept, because the content of those concepts is itself the object of evaluative disagreement. And here now the answer, why do we need? Why is there such a thing as a constitution at all? On the assumption that in morally divided societies, nearly all citizens will regard some of their polity's coercive, political and legal outcomes as deeply wrong, unjust, and even repugnant. The problem of political legitimacy is to identify jointly shared constitutional terms on the basis of which citizens, we can still collaborate despite such repugnancies. So accordingly, the function of a democratic constitution is to enable citizens to talk to each other, to continue conversation, to subject ordinary democratic lawmaking to the framework of a higher law of lawmaking that all democratically responsible citizens can reasonably endorse. Hence, a democratic constitution embodies a conception of legitimate demands citizens may place upon each other through coercive laws and the rightful expectations they may have with respect to one another and government's conduct. As a publicly recognized statement of this framework, constitutional law serves as a shared basis for civic reasoning and agreement for ongoing constitutional interpretive dialogue. So this is, yeah, I come to the conclusion. So this is an interpretive account. It is a content-dependent account because we constantly have to ask what are the reasons behind, what are the reasons for salience. And the hope, of course, is that citizens who radically disagree about politics may still come to see their continuing disagreements as controversies about the best interpretation of fundamental values they can share, rather than simply as confrontations between two different worldviews, neither of which is comprehensible to the other. As long as citizens can believe in the possibility of persuading others, they can regard constitutional law as their own, and that would account for the publicness of a constitution. So I will stop here. The other 2 points I will be silent on. Thank you.
Thanks, Oliver. Great. Would you like a couple of minutes, just a few to respond, and then we'll bring
Yeah.
it forward.
Yeah, I will be, incredibly brief, maybe I will not do the full justice. I think that your analysis or about the possibility of a third form of legitimacy, I think should be covered under my analysis of representation. What I did in this chapter was to say there is representational legitimacy that makes it the case that the laws are authoritative by virtue of the fact that we chose them, selected them, or they represent our inner self. And there is what I call reason-based constitutionalism, which is based on the idea that the content of the constitution is good. Japanese constitution, for instance, was imposed on them by Arthur or whoever. They can't claim that it's representative. Now they can, but doesn't matter. But at least they couldn't when it was established. And of course, it's true about the German constitution. The Americans were very interventionist in making determinations there. And I say these are two forms. And you say that you speak about the third one, which is a matter of interaction between reciprocity between the authors of the constitution or the leaders or whatever, of the political elites and the people. And I would say this is a form, this is, I think, falls within representation, because the idea is that what the people ultimately say determines the norms, that determines the norms, but they are informed by this dialogue or something like this. So I think I ought to perhaps acknowledge this as a possibility. Now, with respect to Chile, I'll only say one word about what you said about Chile. If people believe that the constitution is legitimate, even though they've never chosen it and was never selected, it must be something like reason-based constitutional. Must be based on the idea that they look at the content and they say, it's a very good constitution. This is, I think, the German understanding of their own constitution, because it's not selected by them. And what I argue is that this distinction has very many doctrinal ramifications, which I elaborated in a paper that was published in the past. Now, with respect to Oliver, I thought about what you said about the content base, and what I said is that I think there is something called that you can call potential normativity. That's I didn't think about it in the following sense. I don't think that characterization of something as constitutional or not hinges on the question of whether it's just or right or good or whatever. So in this respect, I'm committed to content independence. So if Saudi Arabia puts belief in God in the constitution, I'm not sure I like it particularly, but this, from my perspective, will be a constitutional provision. Why? Because what they want is that people will recognize it, engage with it, accept it, even if the values underlying it are wrong. When I say potential normativity, I mean that there are some values that are normatively justified, and that it is important that we recognize this and I think, think about punishment. We can punish people who have not done anything or not done anything wrong. We can punish people who are criminals, And I think punishment is potentially normatively justified, yeah, or required, and the same way I regard constitution. In other words, constitution can endorse values or things that are not strictly speaking normatively valuable. In fact, they can endorse things that are appalling. But under my characterization, a person who legislates or entrenches the constitution is interested in people recognizing, engaging with it, and so on and so on. But it could be a bad value, or it could be a wrong value. Thank you very much, and I hope I'll have an opportunity talking to you. And yeah.
Thank you very much for that.